Okay, so I'm going to get into it here, folks. So thanks everybody for coming to, I guess, lecture number 10. One more next week. Gail's going to be here doing a class on the history of the Cannabis Buyers Club. So quite looking forward to that myself as well. But today is my last lecture of this semester, and I'm going to focus on Health Canada and the medical marijuana access regulations that are in place here in this country. I guess it goes back in some ways historically, before I get to how it's working right now, to the 1990s when individual Terry Parker, well, actually, sorry, I should go back further. Jim Wakeford and another individual, Jean-Jacques Parizeau, I could be wrong, but anyway, I can't remember the exact year. I think it was 1998. A court in Ontario ruled that an exemption 56 should be granted for the medicinal use of cannabis to, well, Jim Wakeford was the most well-known of the two. The other individual was not so public, at least not in English Canada. I believe he was a French-speaking person. The Controlled Drugs and Substances Act, the CDSA, had only come into effect in 1997. Before 1997, we had a combination of the Food and Drug Act and the Narcotic Control Act that was regulating different drugs. I think like magic mushrooms were under the Food and Drug Act, for example. Like it was really not consistent, and all of the different substances weren't under one set of rules. So the CDSA in 1997 was essentially combining all of these old laws, but it doesn't exist as an isolated group of laws. It's bound to the Canadian Charter of Rights and Freedoms, for one, in this country, and secondly, it's also bound to the 1961 Single Convention on Narcotics, which Canada and pretty much everybody else in the UN signed on to. And in a way, I'm going to kind of start a bit with that. I've punched up an excerpt from the 1961 treaty, and it doesn't put it here, but there is an exception allowed for medicinal and scientific use of cannabis and essentially all other drugs that are listed. And so, these, the 1961 convention was considered when the MMAR was brought in theory, it didn't really need to be, because there was this allowance for medicinal use. And it's ironic that now our government will at times point to the 1961 convention as something that ties their hands, when in fact, when it comes to medical use, it certainly doesn't. On the other hand, I'm going to talk a lot today about designated growers and people growing their own medicine, which wasn't initially allowed. But if you read here, the first section there under the control of cannabis states that if it is going to be allowed, right? So again, you know, the 1961 convention was written to allow for medicinal purposes, right? And so there is rules that Canada can abide by to process cannabis for medicine. But as you see, they're supposed to be using the same controls applied to poppy, and the use of various opiates made from the poppy plant is very common. Most of the painkillers that are being fed to people are made from the plant. And so there's a lot of rules and regulations, and I've seen pictures of these huge poppy fields in England, for example, with factories in the background and communities in the background, and people don't even realize that it's, you know, poppy and opiates that are being grown in the fields. It's just, and so there are a lot of rules and regulations to allow for these things, but ironically, Canada has chosen to ignore that particular section, and as you'll hear, in some ways, almost create a program that has allowed for this plant to flourish far beyond strictly medical uses. And so, anyway, claiming to be bound by the 1961 Convention and other rules in the Controlled Drugs and Substances Act, the Minister of Health was told by the courts to grant exemptions for medical purposes to individuals that proved they had a need. Well, that all sounded great, right? 1998, we're going to allow for the medicinal uses of cannabis. It was very well known of at the time. You know, like I started up my club in '96. People of age were dying by the hundreds, if not the thousands, every day in the state of California and such. People knew of it being good for cancer and all these various things. So, you know, 1998, people felt like the time was right. Let's help sick people, and everyone except the government, that is. The Liberal government was in charge. Alan Rock took over the portfolio at some point. He wasn't initially in charge of it when these exemptions were first granted. But when he took over, it didn't open it up any more than it did before. The Minister of Health was very reluctant to sign exemptions. It was very cumbersome. And so the next one to bat was Terry Parker. Terry and his lawyer, Alan Young, more importantly, was able to argue that the exemption process was essentially arbitrary and illusionary, dysfunctional, using the Morgentaler case, which is quite relevant and to this day, so I'm going to mention it a bit. I don't know when abortions became available in Canada, but up to the 1980s it was a very cumbersome legal process, very emotional for the women to put themselves through it, very harsh environments that they were subjected to when they were trying to apply for abortions. They were virtually unavailable unless a woman's life was pretty much at risk, and even then it could be often too late by the time they got authority or permission for them to actually have abortions. So Dr. Morgentaler just decided that he's just going to do it. He had the technology, the means, he started setting up clinics. They started to bust him. He argued, much like myself, that he had a civic duty to provide for medical necessity, even though there was a legal means to gain abortions. It was so illusionary, and the courts agreed, that it was ineffective and inadequate, and he was justified in taking that role on. Ironically, even though no one will get busted providing abortions if they're doing it in a clinical setting like Dr. Morgentaler, there is no law in Canada stating that abortions must be provided in every health region. Different health regions in this country can decide whether abortions are available or not. Some in the prairies are very controlled by different, say, religious groups or people with religious thinking in mind that prohibit the availability of that in their hospitals, health regions, and people in different parts of the prairies would go to the major cities like Calgary. So it's still not working yet, but the government was condemned for having this illusionary program. And so, using that case law, the Ontario Court of Appeal said that the exemption process was just completely dysfunctional. You need to come up with a better program. In my newspaper, the Cannabis Digest, if you fold it out, you can read excerpts from the Parker decision. It's very well written, very well thought out decision. And essentially, the courts determined that people with medical necessity or chronic pain needed to have a legitimate access to this medicine. And they didn't tell the government how to do that. In some ways, we're quite blessed to have a judiciary and a legal system that's fairly separate from the politics of this country. And but at the same time, while the courts will tell the government that they're wrong, they don't often like to tell them what to do instead. So they just said, okay, this isn't working, you got a year to come up with something where people will legitimately gain access to this medicine if they're required to use it or their doctors permit it. And so it's hard to know exactly all the agendas at play when the Liberal government came up with their ideals. Certainly the pharmaceutical companies have got a heavy lobby in Ottawa, and while only one company could get the contract to supply the raw herb, it certainly was in the best interest of the pharmaceutical lobby to, in my opinion, have a very poor quality of cannabis available to the majority of people, and at the same time develop alternatives, skin products, inhalers, pills of various types. They have the sativa spray that JW Pharmaceuticals been developing. And so, like I say, it's exactly what they were saying behind the scenes is hard to say, but the government put out a tender for a contract, which was really disingenuous, I believe, even though the exact company to win wasn't secured from the beginning. They really weren't clear on their intentions. A lot of growers and even some small towns in Canada put applications forward to grow this medicine for people. Really, the pharmaceutical company was the only one likely to get it because of a number of reasons. One thing that Health Canada locked in when they gave the contract eventually to Prairie Plant Systems was the patent for essentially growing cannabis. Part of the contract of supplying cannabis for research purposes initially, they set up the lab to grow pot for research. It wasn't actually meant to distribute for people, which is a half-cocked idea that got struck down in 2003, where the court said, no, you have to provide access. You can't just, on one hand, they came out with licenses to grow. So they said you can have a license to possess, or you can have a license to grow, or a designated grower. That was how the government, when they came out with their program, told people they would get access to it. It wasn't from Prairie Plant Systems, as it is now. People kind of are confused because it's been so long. But initially, the Prairie Plant Systems pot was just supposed to be used for research. And so, ironically now, the Conservative government a couple of years ago actually canceled all funding to research. So it's not being used for research at all. Not any of the cannabis that's being distributed, none of it that's being grown for medical purposes. The only study in Canada that's being, no, sorry, I shouldn't say the only one. There isn't a single federally funded study. Dr. Mark Ware is doing some research in McGill on chronic pain. There's a number of researchers at UBC that are doing stuff, but it's independently funded through various mechanisms. It's not funded through Health Canada's medical marijuana program, or in essence, to my knowledge, really any of the funding comes from it at all. It's totally other groups funding research on all of this now. But when, again, that contract was granted to Prairie Plant Systems, part of what Health Canada does, and it's been very awkward for Health Canada. I don't want to, a lot of the bureaucrats in particular have had their hands tied by political decisions and things that aren't something that they've contrived necessarily. And they've never had a court tell them to make a drug legally available for medical purposes. They've never had a plant included in their pharmacy of drugs that are available. They just can't get their head around it. It doesn't fit their paradigms. For example, prescription drugs in Canada get a drug identification number, DIN number it's called. And when you have this DIN file within Health Canada, what's included in there is the standard operating procedures in the production of the drug. And so when it comes to cannabis, after being granted the contract, Prairie Plant Systems developed standard operating procedures for producing cannabis, submitted them to Health Canada. Health Canada went and looked, yeah, that looks like a great way to grow pot. Oh, works for me. There it is. That is the patent for growing cannabis. That is owned by Prairie Plant Systems, not Health Canada. And so Prairie Plant Systems has the right and the authority to in my sense, the obligation to help people grow good medicine. But they're not. They're keeping that information private. And Health Canada can't even help people grow their own pot. They're giving out licenses, giving out designated grower licenses, but